All right, perfect. So hello and welcome to another episode of the ICC Academy COVID-19 Briefing, an interactive video series where we explore economic and health implications of this coronavirus pandemic and what must be done to ensure successful recovery for businesses big and small. I'm your host, Thomas Paris, and in this episode, we will discuss the impact of COVID-19 on dispute resolution services. Our special guests today include a great pairing, both the Secretary General and the Deputy Secretary General of the ICC International Court of Arbitration, Alex Fessas and Serra Moura. These briefings will kick off our collaboration between ICC, the United Nations, and the World Health Organization. During this session, we will start by running through a few topics led by Anna, followed by an audience Q&A session for the last, let's say, 15 to 20 minutes. So we invite everyone to send your questions through the chat and we'll go through them together. So let's kick things off. Anna, the floor is yours.
Thank you, Thomas. Ladies and gentlemen, good morning, good afternoon, good evening. It's my greatest pleasure to welcome you to this webinar and this new setting. I think we are all getting used to this new reality. It's the first time that I'm going to have the pleasure of interviewing Alexander Fessas, ICC Court Secretary General. And let me start by thanking you all to be here with us. It's quite impressive, the number of participants, and I really hope that you are well and your families as well, and that you stay safe throughout these difficult times. Without further ado, Alex, I know that you are not aware, but I will not stick to the script that we have built together, but I will start with a more personal question for you. We have both joined the ICC in 2011, probably with, I think, 3 months difference. And I think that not many people know your internal parcours at the ICC. We all know the members of your team that you have been working quite hard since day one. But maybe we can start by you sharing your, with the audience, your internal parcours at the ICC.
Sure, Anna, and thank you. And greetings to everyone. Good morning, good afternoon, good evening. There's a slight pressure that I feel, and I'm sure that it's shared with Anna as well, knowing that there's about 2,000 people who have registered and probably are heavily interacting already from what I can see on the side of the screen. Welcome, everyone. Again, it's a big pleasure and honor to be sharing current perspectives with you and being hosted by the ICC Academy and interviewed by the Murphy Brown of arbitration, Anna Serra Moura. So it's true. I think we both began with about 2-3 months difference at the end of 2011, Anna. In a way, I think we had similar backgrounds. We both studied in Europe, and once we got through the bar exams, we started working at boutique dispute firms, and then ultimately our paths led us to ICC. I joined what used to be at the time the Eastern European team, given that Greece, for some reason, and Cyprus were qualified as Eastern European jurisdictions. And then progressively, I had the good fortune of seeing case management through different case management teams. I was promoted to counsel, and I was assisting parties and arbitrators in their cases in North America, the US and Canada primarily. This was in anticipation of the switch that happened ultimately in 2014 with the move of that case management team to New York. And once New York became operational, very soon thereafter, I was promoted to managing counsel. And I had the good pleasure to work with all case management teams, the leadership of the Secretariat and the leadership of the court. And that ultimately led a couple of years later, or 3 years later, to my current position as Secretary General. It's been a very fulfilling and interesting ride so far.
True. I think that we both committed to stay 2 years, but nine years have passed by quite quickly. Alex, how have you shaped the ICC, and how has the ICC shaped you?
Good question. I don't know if I have shaped ICC so far, or have completed what I started out to do in July 2017, or we started out to do. But I think there's an important legacy out of everyone who's actually sat in the chairs of management of the Secretariat of the Court. The list of past secretaries general and deputy secretaries general, managing counsel is impressive and at times even daunting. I think what each of them strived to do, and I think to a very significant extent managed to do, is two things. First of all, embrace and implement the power of change. And I think what makes ICC dispute resolution services so widely successful and relevant in the world of disputes worldwide is precisely the fact that, as probably we will be discussing in more detail or some depth today, Anna, the fact that things need to adapt and things need to change. And I think in keeping with ICC's general philosophy, ICC dispute resolution services have been extremely pivotal in embracing change and making change that works and works to the benefit of parties, arbitrators, and other neutrals. So that is my basic mission. As to the way that ICC has shaped me, I have to say that when I originally applied to join the Secretariat, I didn't really expect the richness and the diversity of the experiences that case management can offer. I say this because probably I didn't join at a very early stage of my career. I was already practicing for a number of years. I had a little bit more than just notions of what arbitration is, much like you. So I think my approach to case management was not just administrative. It was it was filled with a lot of curiosity and with a real need to transmit or basically move the experiences that I've had as counsel or in assisting tribunals to the next level. And so the user perspective, I think, was extremely important in making sure that our message is relevant. And the biggest influence I think that I've had comes both from an internal point of view and an external one. The internal one is this wonderful, unique array of colleagues that one gets to work with every day. And every day is not 8 hours a day. Usually it's a lot more than that, given that the sun really doesn't set. In ICC arbitration, we start with Sao Paulo and New York, and we finish, or maybe it's the other way around, with Hong Kong and Singapore, with Paris in the middle, and now Shanghai, Abu Dhabi, and a number of other places. So it's that constant engaging interaction that I find so fulfilling. And then, of course, that is mirrored with regard to the work that we do with our users and arbitrators across the world as well. So I think these are the two main influences that I think make this so fulfilling.
Thank you, Alex. You mentioned that adapt to change and embracing change is one of our characteristics. I think that's quite relevant in the current circumstances with the COVID-19 pandemic. Do you think this is the biggest challenge you face as Secretary General of the Court?
I think in many respects, yes. I think this is something that is unprecedented. This is something that was unexpected. And even as one tries to come to terms with it on a day-to-day basis, one only realizes that there is quite a bit of it, and there are different layers of how this pandemic actually affects our professional and private lives. And being the person who's operationally responsible for them, the management of the Secretariat and DRS, I think is a bit of a challenge in that way, in multiple ways. You need to take care of your staff, you need to take care of your cases, you need to take care of your budget, you need to take care of your projects, and you need to take care of your users and arbitrators. So it is by any respect, I think, the biggest challenge by far.
Thank you. You already mentioned that the ICC Court is a global arbitral institution, and you mentioned some of our case management offices that are in 5 different countries. We have regional directors and rep offices in 7 countries as well. Knowing, because I have the pleasure of working with you and together with Jiv, our managing counsel, that we have been working around the clock to keep our teams safe And while we ensuring business continuity, can you share with our audience the measures and the steps that we have been taken since January or even December in this regard?
Sure, with pleasure. I think, as with any business, especially businesses in the service industry, there's two main things that one needs to take care of in times like these. The first one is business continuity, and I think that's extremely important for all ICC users. The second is safety of our staff, and I think we need to be very vocal about both. And I think it's also important to stress that the best way forward is to balance the two and fulfill both facets of this challenge. Now, COVID, in a way, didn't really catch us completely unprepared. I should start by that, because I think any challenge and any change is important, but we also need to focus on the good aspects of it. And I think ICC preparedness in that regard is quite important, and I wish to emphasize it. Now, first of all, because of our structure and the fact that, as you mentioned, we have case management offices across the world, we had the good misfortune, if I can say that, to be exposed already to the risks and challenges of this virus before other colleagues in different institutions and practitioners in different areas of the world. So already with the start of the Chinese New Year celebrations, it was very clear that there was going to be an impact on case management activities coming out of Hong Kong and ultimately, of course, out of Singapore. We have a rep office in Shanghai as well. So it was very clear that there was going to be a risk that we needed to manage. And then again, speaking of the proactivity of the structure of DRS, I think in that regard, we tested and we tried and ultimately we applied across the board a number of novel practices to maintain business continuity and to ensure that our staff remains healthy. Now, as the COVID and pandemic basically moved westward, ultimately there was need for better coordination across all case management offices, indeed, between different ICC departments, DRS and our colleagues across different ICC activities. And ICC, I think, was very pivotal in realizing that that level of coordination was necessary. A COVID response group was formed immediately, and that helped us to monitor, in the beginning almost on a daily basis and ultimately on a weekly basis today, the situation globally. And that speaks to the heart of crisis management and the good advantages that come out of good management, I think. Now, we have also been quite diligent in moving beyond, above and beyond what governmental recommendations have been at times. And again, that is important to stress that safety of our staff is paramount while we are in a position to ensure business continuity. And for that, I must say that ICC DRS was greatly assisted by technological solutions. Again, I think we are fortunate enough to be based in France, and France already had a crisis that burst on the universe in the end of November, beginning of December last year, because of extended strikes that basically paralyzed the country. Now, that meant that we had to be prepared well in advance of the end of 2019 to have the full staff operational through fully mobile posts. And that was done. And once more stringent measures were put in place in Paris and ultimately in other offices in New York, Sao Paulo, etc., staff was able to switch to a fully mobile environment within a matter of just a few hours. And I think that is phenomenal. And you and I know very well that there have been colleagues in other institutions and firms and even in-house who may not have been as fortunate as us. So I would like to shout out to our friends at the IT department for making that possible. And then ultimately, I think communication is key. We've been communicating very openly and directly with our users since confinement measures were put in place, or even before that. A first comprehensive communication went out in the middle of March, and we have been very attentive, again, to the needs of our staff, both with regard to their professional obligations and, of course, with regard to their general well-being. The court is open for business. The Secretariat is doing well. The staff is healthy. The staff is operational. and life goes on.
Thank you, Alex. And indeed, I think we are extremely lucky because our technology allows us to reproduce the same environment, almost the same environment that we have at the ICC now from our homes, and that's very helpful. Now jumping into a more the specific topic that brings us together here today. Last week, more precisely on 9th of April, the court has released its guidance on possible measures to mitigate the effects of COVID-19 pandemic, with potential means and tools that arbitrators and parties may consider using to maintain efficiency and fairness of arbitral proceedings during this crisis. Could you share with us what is behind the scenes in the creation of that guidance note, and of course its underlying considerations?
Well, COVID-19 is an economic and societal crisis of unprecedented proportions. I think in our lifetimes, and probably that applies to prior generations as well, there has been no equivalent. Crisis forces us to think, and crisis forces us to act. And I think the reason why this guidance note came to be is precisely that. We were well aware from early on that pending cases will encounter disruption. I think we also knew that new disputes will be generated as a result of COVID and other related consequences. And we also knew that those new cases will also probably experience some impact. There may be travel restrictions, there may be additional health concerns, and a number of other factors. So this was definitely the time to act in two ways, I think, in exploring ways to minimize or avoid disruption through the thoughtful use of case management. And also, in a second way, to highlight existing techniques and additional steps that can be taken or maybe considered to be taken in order to streamline proceedings. So those, I think, are the underlying principal considerations that paved the way for this guidance note to come. Obviously, there are other groups, professional associations, institutions, and law firms who have been thinking similarly. And in no way is this guidance note meant to replicate things that can be found elsewhere or to be seen as a single source of reference for the way forward. I think one of the wonderful things that happens today in the dispute resolution community is that it's a very free and flowing exchange of information on good practices and possible ways to tackle COVID-related delays. The working group is basically the guidance note is a result of a working group that was established by the ICC court and its secretariat. It was established and conducted its work and completed its work in 7.5 days, I think, and those were very intense 7.5 days. And again, a very, very fulfilling experience, I believe, for everyone involved. The working group was chaired by Marnix Leijten, who is a vice president of the ICC court, and its members were drawn from the group of vice presidents and the president, of course, Alexei Moura, and a number of members of the ICC governing body for dispute resolution services, which is a branch of the ICC executive board. And in their work, of course, they were assisted by the secretariat. And I should also mention the case managers themselves, who submitted very useful and interesting case reports on the basis of what they saw.
Thank you, Alex. The note has two main sections. The first related to mitigating COVID-19 related delays, which is then split into two subsections, one increasing the efficiency of arbitral procedures, and the second one on service of documents and notifications. And then we have another section on guidance on the organization or holdings of virtual hearings and meetings. And within that section, we have means of conduct conferences and hearings, cyber protocols, and and procedural issues. Maybe let's turn each one. Let's take each one in a turn. We have 1,500 ongoing cases. In 2019, we registered 851 cases with more than 2,500 parties from 147 countries. I doubt that other institutions...
I always love it when you say those numbers so casually, Anna.
But I doubt that other institutions have such a diverse caseload in terms of regional diversity here. So that's, of course, gives us a very good sample of the potential impact that COVID-19 may have on cases. What are the specific measures to mitigate potential delays that the guidance note makes reference to?
Well, I think that's the best segue into the whole philosophy and ultimately the guidance that this note provides, Anna. The first point that I would say is sort of like I would like to state is that this pandemic does not alter the fundamental principles on which ICC arbitration rests and on which the court operates and on which case management operates. And I will need to make reference to the ICC rules because I think that principle is very well established in the rules themselves. So if one looks at Article 22 of the rules, 22.1, the rule sets out a fundamental principle and a shared obligation between parties and tribunals, in fact, on conducting proceedings in a cost-efficient and time-efficient manner. Now, that general obligation, that general mutual obligation, again, is then broken down in different subparts throughout the rules. Article 25 of the rule speaks of the tribunal's authority to establish the facts of the case and sets out a principle that the tribunal may do so by all appropriate means and within the shortest time possible. So I think within the overall economy of the rule, of the rules, the elements that we are now finding extremely relevant in the context of COVID-19 case management are already set out. So increasing efficiency is indeed the first big chapter, if you like, of this note. And in that regard, I should say that some of the techniques that might be utilized by parties and tribunals are not necessarily extremely new. There's been good work that had been done already in the context of the revision of the ICC rules in 2012, and that has been over time progressed significantly through court practice, through an additional revision of the rules. This will continue because there's another rule revision coming up over the next few months. And ultimately, of course, with the good work that has been done by the ICC Commission on Arbitration and ADR on efficient case management, on guides to in-house counsel, on the use of IT, and so on and so forth. The rules do set out, I think, good case management techniques in that regard. And I consider that there will be of interest, again, to parties and tribunals in furthering their understanding of ways in which to keep cases on track, to the extent, of course, that they're relevant. And that would go to, for instance, bifurcation, when hearings have to be rescheduled and postponed to a later time. Other issues to be determined that have been fully briefed already, which can be addressed in the context of partial awards, while the main segments of the case need to wait for the hearing. Other discrete issues in the context of a party's dispute that could be resolved on a documents-only basis. Could the parties agree on a list of facts, or agree on uncontested facts, or on lists of issues to be determined? Can the parties be assisted by tribunals in narrowing the scope of the dispute? And again, those are things that can actually work under the appropriate circumstances to the benefit of efficiency in the proceedings. It is perhaps of equal relevance to consider whether certain issues may be identified as dispositive issues and benefit from limited document production without witness evidence or the assistance of experts. And then ultimately, Again, there's guidance in the general note on the conduct of arbitration with regard to the expeditious determination of unmeritorious claims, which might be helpful in this context. And of course, one of your favorites, expedited arbitration, is the segue, or rather the avenue that has been carved with the 2017 amendments to the rule, something that could be considered as helpful for some disputes, at least, in order to maintain a certain efficiency in the proceedings and getting disputes resolved. So those would be my early remarks with regard to techniques that are probably already known and available to everyone, and which could be visited in the context of the again, unprecedented crisis that we're all experiencing.
Thank you, Alex. And one of the techniques that is suggested in paragraph 8 is organizing midstream conferences with the parties. And I do remember having a case when I was counsel of the Latin American team, in which the parties were quite litigious, and that was extremely helpful in those times. Of course, the midstream conference was in physical presence, but it was really helpful in making the parties focusing on what was essential for the arbitrators, and I would highlight that one. And another one on expedited rules provisions and the possibility to opt in, just to give a view of since March 2017 to date, we have administered approximately 150 cases under the EPP provisions, out of which 55 were opted in by the parties. And we had a case in which the amount in dispute was over 100 million. So I think indeed it's a very helpful and useful tool to be considered by the parties. And sometimes even the arbitrators encourage the parties to opt in when they see that the case is not extremely complex. Just before,
if I may, an afterthought on that. I think this speaks to the power of change. Expedited arbitration is something which in different guises has been approached in the past as well, through fast-track arbitration, through an opt-in system. What we have seen now after 3.5 years of application of the 2017 expedited arbitration rules is indeed that their value extends beyond the actual cases that would automatically fall under their field of application. And that is good case management. Actually, that is good case management from the parties and the tribunals. There's a question that somebody asked with regards to whether this, what we're seeing in terms of procedural or case management approaches in COVID times, will also lead to a change in the way that we as a community, approach case management in the years to come. I think that's a very good question. I think ultimately what we are discussing today is not something that will have, I'm not speaking of the guidance note, but I mean what comes out of it, I think, is practice that will probably not have an expiry date that will be the same as the COVID pandemic. Hopefully this is, again, a time of significant change that will allow us to consider efficiency in much more concrete terms and at a time that it is mostly needed.
Knowing that most probably costs will be more than ever an important consideration for the parties in light of the circumstances. Just two comments on questions that we have been receiving. First, the slides, they are already done on purpose, knowing that our pictures will be on top of the slides, so they are not overlapping any text. The other comment is that the note is available on our website for download in case you need it.
I think also the Academy has a resources link, and it can also be accessed through there.
Thank you for that, Alex. So moving to the next subsection on service of documents and notifications. And this is something that is actually a follow-up on the urgent communication that we have already issued mid-March. And it's something that we have been receiving a lot of queries from the parties. So what are the main takeaways from this section?
On service of documents. Well, yeah. I think, I'm sorry, I need to flip the slides as well. Thank you for the pun. I think the important, there's a distinction maybe to be made there, because part of that activity is something that comes at the initiative of the Secretariat. And then there's a second part that goes more towards arbitrators and parties. Now, with regard to yours and mine, our familiar territory, we had to react. And again, we had to react promptly and responsibly. So parties were informed that a request for arbitration should be submitted in electronic form together with their pertinent exhibits. This is not a change of the ICC rules. This is actually something that is fully compatible with the ICC rules. It reduces time, it reduces having anomalies such as not being able to deliver to an office that might be provisionally closed, which is unfortunately the case right now, physical office I mean, which is the case right now with Singapore and Hong Kong and Paris and New York and Rio and Sao Paulo. But it also allows the Secretariat to streamline its internal processes. And it's important to note that, because once the case is assigned, the case management team will then reach out to the claimant party and inquire further whether we can actually notify to the responding parties the request for arbitration by electronic means. If that is something, and again, that is compatible with Article 3 and Article 4 of the ICC rules. So if that is something that we can do with the agreement of the claimant parties, then we proceed on that basis, and we've done it on many occasions. Now, if that's not possible, then of course we can assure delivery by courier service, or at least dispatch by courier service from most of our offices currently. Now, with regards to arbitral tribunals and parties, I think it's important, and again, probably this is not extremely new. It's already included in the note on the conduct of arbitration, that the general note that has been drafted for some time now. We do encourage everyone to communicate by email and to dispose of paper. I think it's extremely important, but it's not just a general condition. There are a number of other things that can happen on more focal points during the life of an ICC case. Terms of reference, for instance, to the extent permissible, they can be established by electronic means. And that's perfectly acceptable, again, if everyone agrees and there are no legal implications in that regard that would create anomalies. In terms of awards notification, I think this is extremely important, because notification of awards is of the essence. That is what the parties need ultimately at the end of the case. So we are asking tribunals, and it's been very effective, I think, and I think also acknowledged by arbitrators across the world, that we need to know in advance when an award will be coming in original forms, because then we can invite tribunals to send them to the right office that can assure that the award can be compiled and then notified to the parties with the shortest impact, or the smallest impact possible. There is a small dedicated group of professionals, primarily in Paris currently, before it was also Hong Kong and Singapore, who usually once every 7 days, once every 10 days, will go to the headquarters and ensure that awards will be notified, awards and addenda, I should say, will be notified in a timely manner. And then ultimately, another point that comes out of the general guidance that is already around for some time, awards may also be notified electronically. That does come with a certain caveat. Perhaps that's something that distinguishes us from other arbitral institutions. And I say this because I do believe that caution must be drawn to this point. I think awards may be notified electronically to the extent that parties explicitly agree on that. At least that should be the principle, and of course after due consideration of any mandatory provisions at the place of arbitration or place of potential enforcement.
Thank you, Alex. And I think I have to mention that you are one of the members of that small group that goes to the ICC in order to notify awards. And I have to say it because I doubt that many Secretary Generals of arbitral centers would do that for the institution and for the users. Moving to the next section on guidance on holding virtual hearings. And again, making reference to the 1,500 cases that we have ongoing, I guess that we would have a good portion of our cases that would be now or since February, March at the stage of hearing, and that have been directly impacted by the COVID-19 outbreak. What has been the experience and the approach of arbitral tribunals and parties so far?
Well, I think in a way, although it has been about only 2 months perhaps for the greater part of the world that we've been experiencing COVID, or maybe just a little bit longer, we've actually seen a lot of development in the approach. I think the first reaction would be to postpone and reschedule hearings, for instance. And I think probably that would make sense as a first response when you anticipate that this is something that may last for a limited amount of time, and you see openings that would actually not delay the proceedings. So I think that was a healthy approach. And in most of those cases, those issues were completely uncontested. Parties would be in immediate agreement, and tribunals will also usually support them as well. Now, we are experiencing what I would call a second wave of cases that might be impacted, and those are cases which may face, and I would like to emphasize the potential aspect of this, may face a potential delay if postponed further. And if one tries to put all of that together and mix it up, I think we see an immediate impact in order of importance in those pending cases where the proceedings are at the stage that leads up to the main hearing or is very close to that. Then in those cases that have been very recently initiated. And then lastly, with those cases that are about to be filed or will be filed in the weeks or months to come. Now, in that sense, I need to, again, recall a very helpful provision of the Article 22 of the ICC rules, and that's 22.2, which asks of tribunal to, once it has heard the parties on this point, to adopt such procedural measures it considers appropriate in case management. And again, that is an affirmation of the broad discretionary power that an arbitral tribunal will have under the ICC rules. Now, is that new? Probably not. But again, what changes, I think, a little bit during COVID times is the following. The tribunal needs to hear the parties and also needs to consider all appropriate circumstances. And that is not just the length of proceedings, the reason, a pronounced reason to proceed without undue delay, whether rescheduling may cause unwarranted delay, the need to prepare for hearings, but also specific COVID-related factors. Will it be possible later on to travel and to hold meetings, or is that also not something that is immediately available? Will it allow parties to prepare better, or is the case fully briefed already and can proceed? And I think in that regard, one needs to circle back to the case management techniques that you and I just discussed a few moments ago. Now, once that assessment of all relevant circumstances takes place, there's an additional step. And I think the first option is that the tribunal may decide that a meeting in a physical location is necessary. And so if that is the case, I think tribunals and parties should work together towards ensuring the safety of everyone who would be attending at that appropriate time. There is a second option, which is when the parties agree or the tribunal determines that a physical hearing is necessary and indispensable. They can again consider all the case management techniques that we discussed a moment ago. And then where the parties agree or the tribunal determines to proceed with a virtual hearing, they need to discuss the special features that that hearing might have. And I think you and I will have the opportunity to discuss this in a couple of minutes. Now, there are situations where a tribunal may be minded to proceed with virtual hearings over a party objection. Now, again, I think the guidance note is very clear in that regard in stating what, in a way, might be the obvious, but I think it's helpful to recall it. All appropriate circumstances need to be considered. And that includes also the enforceability, the potential enforceability of the award, obviously. And there's a best efforts obligation under Article 42 of the award, which the court shares with arbitral tribunals to ensure that any award will be enforceable at law. So I think that is relevant in appreciating the circumstances I referred to a moment ago. The tribunal will also need to reason its decision. And I think that's important because, again, it may be stating the obvious, but good reasoning is usually good reasoning in procedural decisions is actually something that allows the parties to understand where the tribunal is coming from. It allows the parties to appreciate the fact that their arguments may have been given duly consideration. And I think it actually speaks directly to the fairness of the proceedings and the fact that due process has been maintained. Now, in that context, I think both the ICC rules and the practices of the court and the secretariats have progressively acknowledged that there is a possibility to hold a virtual hearing. We can see that very clearly and explicitly in the ICC rules in the context of case management conferences, in the context of expedited arbitration, and also with regard to the guidance on dispositive matters. I think that is something that has been happening, in fact, for quite some time. Now, Article 25(2) of the rules, which speaks of an in-person hearing, could be construed as referring to both parties participating in an adversarial setting before the tribunal on establishing the facts of the case. And actually, if one goes back into the drafting history and interpretation of the rules and the English version and the French version of the rules, I think there is probably good argument to support that interpretation. And again, it's a point for the tribunals to consider in the context of every specific case. Now, the last point that I would say is the tribunals have so far, and definitely in pre-COVID times, erred on the side of caution. And in light of party objections, they have proceeded primarily with maintaining a physical hearing, a hearing at a physical location, or at least ensuring that a part of the hearing will be held under that arrangement. But I think it's very clear on the guidance, and I think it very clearly came out of the discussions that we had with within the working group, that COVID and the unwarranted delays that might, and again, I will emphasize that potential aspect of it, that might be caused, may lead tribunals in adopting different approaches in order to discharge their fundamental obligation under Article 22 that I mentioned earlier, again, considering all relevant circumstances.
Thank you, Alex. And I think with that, you covered an important part of the questions that we are receiving. One of the questions is whether tribunals may order virtual hearings even when one of the parties objects. And I think you cover that by saying that the specific circumstances of the case, including, of course, if one party's object should be considered and analyzed by the arbitral tribunal in its decision. So we need to proceed because we have 1 minute actually for our 45 minutes. So very, very, very briefly.
You interrupting me if I'm babbling on.
Right now, because we have a lot of questions that I think it's important to cover, at least some of them. What are the practical considerations when organizing virtual hearings in terms of cyber protocols and procedural rules that may arise?
Well, there's a number of different things that one can look at. I think, drawing from what you just said, first of all, there are measures that one may consider, one meaning tribunals and parties usually together, in implementing measures to identify and address factors that might affect privacy, security, and confidentiality of a virtual hearing. And one of the very important parts of this note is that it actually provides a checklist that tribunals and parties may use in identifying the elements that they should take into consideration in the context of a cyber protocol, which I think it's Annex 1, and it's pretty. Anyway, I don't know if you can see it, but it's actually pretty thorough. That annex basically speaks on a number of things, technical issues, specifications, available platforms, confidentiality, privacy and security, and all the way down to online etiquette and the presentation of evidence and witness examination. I think from an institutional point, and that's important because probably that's also embedded in the note, but I think it needs to be heard from our side as well. The ICC Hearing Center in Paris has is able to provide standard tech support and explain basic options to tribunals who are interested in exploring that option. We, as ICC, have signed a number of memoranda of understanding with a number of arbitral hearing facilities across the world, and many of them actually also provide certain support or certain technical facilities in ways of platforms or electronic document management platforms that might be of assistance to the parties and tribunals who want to further their discussion with regard to virtual hearings. And then ultimately, as we all know, because we have seen those platforms both in the professional and the private context, there is software out there that has been used, and we've seen it used in our cases. Now, we're not in a position to endorse, obviously. An institution right now, the institution is currently not doing that. But the note does provide a link to a comparative table that explains currently the strengths, potential strengths, and potential weaknesses of platforms that are readily available. And the note is, I think, making it very clear that parties and tribunals should feel comfortable and satisfied that with the desired level of security settings that any of those platforms may have before they proceed. Now, aside the support that we are currently in a position to provide, obviously, power of change comes back. And I think this is, again, where all of this is so relevant. I think the Hearing Center is in a position to further its understanding with regards to how to better support virtual hearings in the weeks and months to come. And probably this is one aspect of the note that I think is extremely dynamic, in that it will be revised as our knowledge of the potential of those solutions, and indeed as the technological support of those solutions evolves over time.
Thank you, Alex. And I will jump to questions, and I will ask you to look towards the future now. How do you see COVID-19 outbreak shaping the future of DRS dispute resolution services, namely in terms of expected new disputes? Will we go back to where we were before, or things will completely be reshaped?
I mean, I think, again, we're in the midst of a very, very significant point in time. So I would think that the current circumstances will actually trigger elements of change, both in the way that we handle disputes as a disputes community, but also in the types of disputes that may come. And again, I think even if we had another 45 minutes, we could actually sit down and delve on those points together, and of course with all our guests. But to give a more of an immediate answer to your question, I think we will be seeing disputes. It's hard to tell exactly how quickly and at what rate. But in terms of industry sectors or economic activity sectors, I would think that we would see disputes arising in the context of infrastructure, construction and engineering projects, and energy-related disputes. I would assume that there is something to be said about gas pricing in the near future. Both items, infrastructure and energy, are, as you know, quite important in the context of ICC dispute resolution, because we have a significant part of our caseload coming from those two industries. I think states will probably be involved in disputes that might be both contract-based and treaty-based. I think we will see a lot of that. It will be interesting to see exactly how the discussions for our ISDS reforms will proceed once possible. We will see disputes coming out of life sciences and healthcare issues. I think we will see disputes arising with more frequency out of what we could call the leisure industries, more broadly travel, transport and tourism. And then, of course, insurance and reinsurance. And I think we'll see financial disputes as well. We'll see bankruptcy. We'll see issues coming out of bailouts, potentially, and a number of other things. There is also an underlying principle that doesn't go to any specific dispute, but in a way covers all of it. And that is the broader issue of access to justice. And I think in that regard, states are struggling. State-administered justice right now is struggling. We know, and there's a wonderful a website that provides updated resources that has been established by Professor Susskind, which is called remote courts, if I'm not mistaken. Yeah, remote courts, which actually lists the immediate measures that states around the world are taking to maintain a certain level of normality in their operations. But we know that that is probably not going to be enough. So I think in the context of ICC DRS, and that includes arbitration and ADR, I think there is a lot to be doing. There is a lot to be said with regard to facilitating the access to justice. Last point, which I probably should have mentioned earlier, looking at my notes, is the role of funders. And I think, you know, an analogy can be drawn between the financial crisis that arose in 2008, 2009, and some of the things that we're experiencing today. And funding in arbitration was at least partly due, I think, to consequences of the financial crunch. So I wonder whether funders will also not have a role to play or some role to play in the way that we see disputes evolving in the next coming years.
Thank you, Alex. And you mentioned ADR, and this is also some questions that we are receiving cover this issue of whether we will see more mediations and negotiations, and we should encourage that more under the current circumstances and probably after. So before giving the floor to the audience and to try to cover some of the questions that we have received, I think we have 100, so it will probably be difficult to cover all of them. But I promised that I would begin and I would finish with a more personal question. And behind this screen, we have 2,000 people that are, you know, learning to live in a different way, working in some difficult circumstances. And we have our users, we have a lot of friends, parties, lawyers, arbitrators, students that are now attending this webinar. Yesterday, I saw that Antonio Guterres, the Secretary General of United Nations, said that this is a time for science and solidarity. For you, this is a time for what?
Well, it's a very good quote, Anna, from Gutierrez. I don't know if I can match that. You know, one of my favorite books is A Tale of Two Cities by Dickens. And given that we are in Paris and we're speaking in English, probably that's, I'll borrow or paraphrase something from Dickens. It was the best of times. It was the worst of times. It was the age of wisdom. It was the age of foolishness. It was the epoch of belief. It was the epoch of incredulity. It was the season of darkness. It was the season of light. It was the winter of despair. It was the spring of hope. Now, if you were asking me that question on a more personal basis, then I would have asked you to start singing with me "Once in a Lifetime" by the Talking Heads, but that's a different story. We can.
I think people would log out. We don't want that for sure. You are a good singer, I'm not, so I would not do that. Alex, one of the questions that we got is if we have seen already an impact in terms of new cases. I don't know whether you wanna cover that. I think we just had a full month in which the pandemic kicked off, so probably we don't have an important sample to share with our audience, but your thoughts on that.
Yeah, no, I see no reason why we should not be transparent in sharing that information, Anna. And I think your estimation is correct. I think we don't have a sufficient window that is wide enough right now to make assumptions. But obviously, looking at the month of March, there were less new filings, perhaps, than what we would have anticipated on a normal end of the third month of the year. Oddly enough, however, I should say that we have received 3 or 4 emergency arbitration cases. And I think, well, not oddly enough, but I think that is also indicative of a push to resolve issues. And I think interim relief or urgent relief is not something that is going to go out of fashion anytime soon. And of course, those are precursors to normal cases. So I expect that to come up. Again, it's difficult to make a forecast with regard to the future, but I think we will have more clarity, hopefully, when we next discuss this publicly. But I would expect that to be clearer probably about 2 months down the line at the earliest.
Yes, thank you, Alex. And I think you mentioned the emergency arbitrator, and one of the questions that we got is how we are working remotely. I think you already covered that, but we are very well equipped for that. And I think the emergency arbitrators are a fine example of how well equipped we are and how responsive we can be. One of the emergency arbitrators that we have received was received on Good Friday, I think. So, and we managed to comply with the time limits under the rules.
And another one yesterday at 3 a.m. Paris time.
Exactly, and
within 9 minutes.
Exactly. So indeed, we have been working remotely, but I believe in an efficient way. So the courts, and the question also covered the work of the courts. The courts exactly the same. We have been organizing virtual sessions in order to take the decisions that we need to take in terms of pursuant to the rules. There are
more questions with regard to force majeure. I don't know if that's something that you want to circle back. Yeah.
Yes, there are some. Well, the first that we already got last week as well is whether we already saw cases, COVID-related cases, and I know that you don't like that expression, and I do agree with you, because when we see those cases, they are not COVID-related per se, but it's the consequences of the restrictions that we will see implemented by certain states that could affect the compliance of certain contracts. But I think that one I can reply that we have not seen yet a rising out of the COVID-19 crisis, even though there are always some allegations more related to probably to the payments than anything else, and for the arbitrators to consider the state of emergency in certain countries. But Alex, in terms of force majeure, of course, we have seen hundreds of cases, or maybe thousands. Maybe you can cover that. There is a question that's whether the FIDIC contracts will take into consideration force majeure and the pandemic in their clauses. I think the question should be referred to them. But on the more broader scheme, I don't know if you want to share your thoughts.
I think you covered the broad points, and of course there was a different webinar that was hosted on force majeure and hardship issues this past Friday, and it also covered elements of dispute resolution. I think it's available. I think the webinar is available for those interested. I very much invite you to listen to it. Now, in the interest of time, I would say yes, of course. I think we will be seeing force majeure and hardship issues coming up. With regard to the way that they may be tackled in the context of FIDIC contracts, I think it will be up to FIDIC to decide, of course, and I'm sure that they're thinking of different ways to respond to this. But one way is, of course, to consider the different contracts and whether an update on clauses needs to happen. But even outside the context of FIDIC, I would say that specifically in the context of construction and engineering disputes, we have seen force majeure and hardship cases, as Anna mentioned, for a number of years. And you can think of the broad hardship or force majeure incidents that might have happened regionally or globally over the past 10 years, and maybe even reported in the legal press or the general press in terms of disputes. So I think in that sense, we will see that pattern probably replicating itself potentially across the globe, I think.
I think there is another question on whether we are considering to relax the criteria for EPP, emergency arbitrage, in the post-COVID-19. Maybe you can cover the amendments that we are proposing regarding EPP and the emergency arbitrator in the new set of rules.
Mm-hmm. Sure. Well, first of all, I don't really think that in terms of applicability of the rules, which is sort of like the gateway conditions under Article 29 of the rules, there have been too many cases that actually failed to pass that basic test. And I think that test is there basically to safeguard that whatever proceedings might start will actually be streamlined. So any very complex issues with regard to non-signatories or issues that would go towards a retroactivity of the rules, I think would be difficult to tackle. Now, what we have learned, of course, after administering a big number of emergency cases, is that some of those criteria that were originally envisaged may no longer be that relevant. And again, that comes up also in consultation with FIDIC, that we've had with FIDIC, with regard to other pre-arbitral proceedings that might have been agreed upon by the parties, or with regards to the availability of emergency arbitration in the context of investor-state disputes, ISDS disputes. So we will be seeing probably a crystallization of those 2 points in the context of an amended Article 29 that will come up, hopefully, I think, into effect by the beginning of next year.
Thank you, Alex.
There was a broad question I saw at some point earlier, which spoke with regard to whether we would be sharing information with regards to experiences out of, the issues that we've discussed today in the future. And I think the answer to that is a full yes. I think this first discussion that Anna and I have had today is probably one of many, and probably one of many in many ways that we will be having. And I think we will be seeing that in the context of webinars, in the context of conferences, physically or virtually, in the context of web releases, and the context of articles that will be written. It is our intention, as always, to maintain that flow of information, of course, respecting confidentiality, but seeing basically how we can actually support parties and tribunals in their quest to move their cases forward under, again, the appropriate circumstances. So this is why this guidance note came to be, and we will be fulfilling that mission.
Thank you, Alex. There are some questions on our case management platform that I would tend to think that you would like me to cover. Indeed, and we have been discussing that already over, unfortunately, the past 2 years. We are now approaching the final phase of our internal case management platform and the users acceptance test. So hopefully we will, of course, this is not the ideal momentum to do internal tests, but we are working on finding the right time to do them and to implement our internal case management conference, which will also allow for an external platform for users to upload documents and to be able to access all the relevant information in a secure platform. This being said, and while we have not implemented that, we are working at the same time, and we have already provided the access to secure platforms for parties to exchange documents when necessary. And as Alex mentioned before, we are also working with the Hearing Center in order to provide a full package for virtual hearings very soon. Alex, I don't know whether you want to add something on that, or whether we can proceed with other questions.
Well, there was one question with regard to whether we've seen examples already of any of the points that we've discussed. I don't know if you want to. I'm sure that there's at least one case I know that you would be interested in sharing your insights on. Obviously, it's a very good question. We have seen it. I think we have seen a number of cases where the issue has been either fully agreed already by the parties, or either to move it to a virtual setting, postpone it, and maintain physical hearings. There have been a few cases where there may have been objections. One case that I can refer to immediately is a case in which preliminary motions were going to be discussed in the context of a hearing. And the tribunal decided to proceed with making arrangements for a virtual hearing in that context. After having looked at all the arguments of the parties, and again, those are very well reasoned decisions, and I'd like to emphasize that because I think it's important. So the fact that it was a preliminary motion was important. Parties would be given the opportunity to supplement, of course, their arguments in the context of the virtual hearing. The tribunal considered that the factor of whether the parties had already an opportunity to make full and substantive submissions with regard to the points that would be addressed in the context of the hearing, whether there would be issues with regards to any applicable law considerations, and of course, any earlier objection that the parties may have had in the context of case management conferences on specific modalities that the hearings could take place. And I think that is a pattern that we've seen also in a couple of other cases. Probably I can't refer to them in greater detail because there is a certain element of confidentiality given that those cases are still pending. But it is something that we are seeing, and we also know that there are a number of cases currently where the issue is being discussed between parties and briefed between parties and tribunals. So I think that goes back to the earlier comment that I made, that as time progresses, we will be able to share more insights and more concrete insights in this regard. Now, there's this one case that I know that Anna is dying to mention.
Yes, thank you, Alex. I am indeed, because I think it's a good example. I think we have moved already in such a short time limit from a very conservative approach from arbitrators, and even you mentioned before, right, postponing hearings. What we saw at the beginning was actually hearings being cancelled and not even being rescheduled, and that was of I think great concern for us. I think now, or they move into virtual hearings, or they are at least rescheduled to later on this year or next year, beginning of next year. So that case was a hearing that actually involved multiple lawyers, more than 70 lawyers around the world in different countries, and the parties have agreed with the arbitral tribunal to conduct the second phase of the hearing virtually. And they cross-examined experts, and they did oral allegations, and apparently it was a very, very positive experience to all of those involved in the hearing. So I think we are seeing more this proactive approach in trying at least to have virtual hearings instead of physical hearings. I think I saw a question as well regarding of whether we are considering issuing best practices notes. I think it's clear that this ICC guidance note is a work in progress. As Alex said, our experience will also evolve, and probably this note as well. It's difficult at this stage to say exactly how it will evolve. Let's see our own experience from our cases. It's difficult to say at this stage whether we will issue best practices checklists or notes at this stage.
Anna, we have one question from Laura from ICC Mexico. I just wanted to put this one in before we wrap up. It's from Laura, but it is from Francisco Gonzalez, where they want to know your views on cyber cross-examination. I just wanted to make sure that we covered that before we wrapped up.
I'm not sure I understand cyber cross-examination. If it's the concerns of cybersecurity during cross-examination, I think we can refer
okay.
I mean, obviously, witness examination includes cross, and I think that's very quickly. I think it's important to note that. Can you hear me?
Yes.
Okay. I think it's important to note again that in the context of making sure that due process concerns and efficiency also of the effectiveness rather of the witness examination arrangements are in place. And I invite you to look at the checklist that identifies the issues that need to be discussed by the parties. Now, I think it's important when everybody's working from remote, in a remote setting, to ensure again that everyone will be satisfied with regard to the integrity of the process, and there are ways to do that. So again, I think that the note is quite helpful in providing guidance, and the checklist in providing guidance in that regard.
Okay, great. Yeah, thank you for that.
Yes, I think we see we also have a question of whether we see already delays in the service of arbitral awards. I think Alex already covered that. We are trying to avoid as much as possible delays. Arbitrators are being extremely proactive, and some of those arbitrators are actually attending this webinar in signing the award in counterparts and sending the signature pages. We are also doing our best on our side in order not to delay those notifications. So far, I don't think we have been seeing delays in the notification of awards. Let's see if the restrictions in terms of courier services is more important tomorrow, if we will see those impacts. But so far, we have not seen them.
And maybe two very short points, related points, Anna. The first one is impact on delays on the drafting of awards or the rendering of awards related to COVID. Obviously, the practice of the court in monitoring delays is as relevant as ever. However, the court will exercise sensitivity in approaching and in assessing the delay impact in those cases where the delay is due to COVID-related reasons. I think that goes without saying. I would like to stress that. And the second point that I would like to stress is, again, given that there might be and there will be an impact in terms of the prolongation of proceedings and ultimately the final payment of fees to arbitrators, I think it should be noted that there has been for decades now a practice by the ICC court and its secretariat to proceed with advances in fees for arbitrators whenever the tribunal so requests, and on the basis of the work that has been done and or the milestones that have been reached. And I would like to emphasize that point in order to make sure that there are no misunderstandings on the fact that the court does remunerate tribunals also by way of granting advances and fees. And that is the reality of the times that we're living in, and that is good practice, and it will be used consistently whenever the occasion arises.
Thank you, Alex. I really think we try to cover as many questions as possible, and I really also apologize if we have not been able to cover all of them. Probably we'll do a second webinar and we will try to cover the remaining questions.
Yes, with pleasure. I think it's been, thank you so much everyone for your questions. I'm sorry if we haven't been able to address them all. I wish we could. You know that the Secretariat is always available to answer queries, and in fact, we encourage, especially in live cases, anyone who has broad questions or comments with regard to the practices and the way that we have come about with regard to the guidance note to reach out. Obviously, the Secretariat needs to maintain strict neutrality, and we will continue to do so. But we do hope that the guidance note is something that will assist everyone on the way forward.
Thank you.
Thank you. Yeah, thank you. Thank you, Alex, for your insights. I mean, this has been fantastic. And Anna, for making me completely redundant by taking care of all the questions. You're very professional. I think I'm going to keep you for all the upcoming webinars. This was really great. So I wanted to thank you both for your time. This was really great. And I also wanted to shout out for the audience for your questions and for sticking around not only for the planned hour, but also a little bit longer and sending some final questions over. This was really great. So we hope to see you next week. We have another one on trade finance, but I wanted to shout out. So I will be sending a few extra links in the chat. So if you want to stick around, if you want to go through the WHO survey, but otherwise, yes. Thanks, everyone. As a reminder, we are hosting live broadcasts on this topic, in addition to trade topics like the Incoterms rules, cryptocurrency, leadership coaching, and a lot of others. So sign up on our website for free and subscribe to our YouTube channel. And ladies and gentlemen, this has been another episode of the COVID-19 Briefing. See you next time.
Take care, everyone.